Welcome, Carl Rominger here. Just want to talk a little bit about the Pennsylvania Supreme Court's decision released yesterday in Commonwealth versus Gary. In that opinion, Justice McCafferty, pronouncing the opinion of the court, overrules a lot of history here in Pennsylvania to now allow the police to do a warrantless search of your car as long as they have probable cause to believe that the search will yield the fruits of the crime. In the case at Bar, a fellow was pulled over, and after he was pulled over, he indicated there was weed in the car, and the police went ahead and did an immediate search of the car and found 2 pounds of marijuana hidden in the car. Previously, under Pennsylvania law, as long as the police had probable cause to stop you, but before they arrested you for something, they couldn't necessarily search the car without impounding the car and getting a warrant. That was not always the case under federal law, and in fact, under federal law, for a long time, there's been an automobile exception, which basically says that while the police would have to get a warrant whether it were a house or something else, they don't need to get a warrant for the automobile. Pennsylvania, however, under Article 1, Section 8 of the Pennsylvania Constitution, for many years gave an additional protection, which was basically that the police impound the car and get a warrant. The idea being that if the police officer felt he or she had probable cause, they would have to articulate that to a detached and neutral magistrate who would then take that information and make a determination about whether a search should ensue. Now, if you were arrested at the scene for some other crime, the car could be impounded and an inventory search could be done, and a warrant wouldn't necessarily be required. But imagine a scenario where you're pulled over, for instance, for a minor traffic infraction. The officer then begins to suspect that there's something else going on, drug trafficking or other fruits of the crime in the car. What we've said is if they can't arrest you for an offense, but they believe that the car contains fruits of a crime or evidence of a crime, then under the Fourth Amendment, they are allowed to search it. Under Article 1, Section 8 of the Pennsylvania Constitution, up until yesterday, police officers were instructed to take the car and impound it or hold it while they got a warrant to establish probable cause through a warrant scenario and give an additional protection to the citizen. That protection was removed. Now, the opinion is very lengthy, and in it, McCafferty discusses the history in Pennsylvania. Essentially says, historically, our courts have never really analyzed this right. We've never done what's called an Edmunds analysis, which is a analysis to see if our state constitution does or doesn't offer this protection or should or shouldn't be exactly the same as the Fourth Amendment. In the dissent written by Justice Todd, she goes on to say, basically, well, that's not really true. We've always said that Article 1, Section 8 gave more protections in this area. What does this really mean practically? It means that historically in Pennsylvania, when you were pulled over and the police wanted to search your car, they needed your consent or they needed a warrant. Now they only need to articulate probable cause to believe they'll find the fruits of a crime and they can begin to search your car in length. Now, realistically, this only changes your protections a little bit because most states followed the Fourth Amendment automobile exception as articulated by the Supreme Court over many years. And the Supreme Court of the United States has said you have a lower expectation of privacy in your car and that therefore third parties like the police can then impound or search your car roadside before they let you go or before they arrest you and without your consent, as long as they can articulate that probable cause. So you still aren't required to allow the police to search your car if they ask you to, and you're still not required to let them search your car unless they can articulate probable cause, but that's going to be in their head. And once they've articulated probable cause to themselves and they start to search your car, your only remedy later is to file a suppression motion in the Court of Common Pleas and say that there was not an articulable or reasonable basis that would constitute probable cause, which is more than a reasonable suspicion, that the search would be fruitful. Obviously, these cases won't come to court when the police find nothing, because then there's nothing for you to do, although you could file a 1983 lawsuit and sue them and say that they violated your constitutional rights by searching your car without probable cause. Practically most citizens who have their cars searched and nothing's found are going to go about their way and end the police interaction. Now, keeping in mind that these days you are allowed to record the police and keeping in mind that the police are allowed to record you, and of course most state police cars and many local cars have audio and visual recordings ongoing, it probably behooves you to say, I don't want you to search my car. And if they say, well, we're going to, well, what's your probable cause? If the officer is willing to articulate that, at least you'll then have an articulation of what he or she thought at the moment. It's often said that criminal defendants will, after the fact, meet with their lawyers and try to figure out why they did what they did to explain away a crime. Well, the same occurs when police officers meet with district attorneys. Well, here's the law, here's why you might have had probable cause, and an officer might be tempted to say, yes, that's what I was thinking at the time. Yes, that was what my belief was at the time, which was allowing me to articulate probable cause for the search. So it does allow for some hijinks, although the Supreme Court does point out, and I got to give some credence to this, that impounding your car for a few hours or holding your roadside for a few hours may be more intrusive in some respects than simply letting the police go through your car and you going out about your way, assuming that their probable cause dissipates because they are incorrect that your car is hiding anything. The problem with this decision, as I see it, though, is that Pennsylvania had, at one time, and I think Justice Todd points this out, proudly said that we provide greater protections than the federal Constitution under the Pennsylvania Constitution. Here, the Pennsylvania Supreme Court has now said, no, we're going to restrike the balance in favor of the public good and law enforcement efficiency against individual liberty. I don't think standing alone this decision is a huge problem because it simply puts us in the exact same place as every other citizen of most states and anybody who's pulled over by a federal authority who only has to follow federal law and not Pennsylvania law. So it's a little bit of a change, and the practical protections available to Pennsylvanians and people traveling through Pennsylvania when being stopped or searched by Pennsylvania authorities doesn't change federal authorities and doesn't change your position as you travel through other states or as citizens from other states return to their states. But it's part of an alarming trend where our constitutional rights are being slowly chipped away one by one, where free speech is being attacked, where Fourth Amendment protections are being attacked. Here, Article 1, Section 8, which is the Pennsylvania Constitution, is being attacked. Our Second Amendment protections are being attacked. And it's interesting to see how far this pendulum will swing before individual liberty starts to outweigh collective interest again. Remember that the Fourth Amendment is a balancing test, unlike certain other amendments, and Article 1, Section 8 is also a balancing test under the Pennsylvania Constitution. So government is free to, and the courts are supposed to strike a balance between your reasonable expectation of privacy and society's interest in effective law enforcement. So it's an important decision. It changes Pennsylvania jurisprudence. Hopefully it's just not part of a slippery slope where we continue to lose our rights and our protections. Remain ever vigilant, my friends.